Hello, hello students. Let us continue our discussion on fundamental rights. In this video, we will start with Article 21 of the Constitution. Article 21 of the Constitution. It is said that this is a fundamental right with the widest scope, that is, the fundamental right to life and personal liberty. The right to life and personal liberty. Personal liberty is a natural or physical liberty of a person's body. It is a natural right, but not a right to juristic right. However, the limitations to Article 21 are number one, procedure established by law. Procedure established by law. That is law made by the legislatures. Legislatures in India have the right to take away the right to personal liberty. This law cannot be made by the executive. However, except according to procedure established by law, the fundamental right to life and personal liberty can be taken away. The procedure should be clearly mentioned in the law that the executive is supposed to follow. For example, in the Gopalan versus Madras case of 1951, Supreme Court was to examine this case whether the law passed by the legislature to deny right to life and personal liberty is valid constitutionally or not. The Supreme Court declared that as long as it is a law made by the legislature and as long as the law contains the procedure to be followed to carry on the death penalty, such law is constitutionally valid, even if it violates Article 21. Okay. However, in the Maneka Gandhi case of 1978, the Supreme Court said that law made by the legislature and the law which contains the procedure to be followed and the law which will take away fundamental right under Article 21 should be reasonable, fair, and just. This will be open. However, such a law which is violative of Article 21, even though it is reasonable, fair, and just, it is open for judicial review. The power of the court to examine whether the law which is against article, which violates Article 21 of the Constitution, whether it is reasonable, whether it is fair, and it is just, only then it will pass the constitutionality, the test of constitutionality. This is called due process of law. This is called due process of law. That is, whether the law, even though the law has satisfied the constitutional procedures and it is passed by the parliament, it has to pass the test of fairness, justness, and reasonable. Then it is constitutionally valid. It is not null and void. Constitution of India gives powers to the courts under the procedure established by law, but not due process of law. But the Supreme Court has given to itself the power of due process of law. In the Maneka Gandhi case, Supreme Court has overturned its own interpretation that it gave in the AK Gopalan case of 1951. In Maneka Gandhi case, the Supreme Court gave to itself the power of due process of law, though implicitly. Okay, that is about Article 21 of the Constitution. We will get into further details of Article 21 of the Constitution and the other articles in our next